It is the start of the 18th century in the raw wilds of colonial America. A Pennsylvania woman is searching for a way to sell land to pay her husband's debts. Rather than going to a court, she turns to Pennsylvania's elected assembly. Its members debate. They then vote on the merits of the woman's claim as if they were judges. They rule against her. This blend of the legislative and the judicial functions, so jarring to contemporary ears, was not unique to Pennsylvania among the colonies. In Massachusetts, citizens could file a petition for relief by a private act or by a hearing with their state assembly, and then secure legislative resolution of the matter. In several American colonies, assemblies behaved as courts, ruling on whether married couples could obtain divorces, whether individuals had committed treason, whether defendants should be issued with reprieves for their ordinary crimes, and even how previous legislative enactments should be interpreted. In the colonial world from which the American nation was born, courts did exist, but they had no monopoly on the ability to interpret and apply the law. Instead, colonial judges commonly sat on legislative councils. Governors routinely heard appeals in civil cases. The King's Privy Council, sitting far away in London, heard appeals as well. The lines between what are now imagined as separate branches were pervasively blurred. Little wonder that the future President John Adams would write in 1766 that the first grand division of constitutional powers lay between those of the legislature and those of the executive. Little wonder he would opine before the Constitution's drafting that the administration of justice properly fell in the executive part of the Constitution. Little wonder, too, he saw no role for courts independent of both the legislature and the executive.